Life after death row, the psychological aftermath of exoneration. Imagine walking through steel doors into sunlight after 3 decades of knowing you could be executed at any moment for a crime you didn't commit. The locks click open. Freedom rushes in. But freedom, it turns out, can be as disorienting as the cell that held you. This is the paradox of exoneration from death row, a phenomenon that has affected at least 200 people in the United States since 1973, according to the Death Penalty Information Center. These are the survivors who escaped America's ultimate punishment, only to face an invisible aftermath that society rarely acknowledges and even fewer understand. The numbers tell one story. Since the resumption of the modern death penalty era following the Supreme Court's 1972 Furman v. Georgia decision, over 200 individuals have been freed from death row after proving their innocence. They spent an average of a decade behind bars. Some waited for nearly 3 decades while the machinery of justice ground slowly toward truth. Roughly 1 person has been exonerated for every 8 people executed in America. A 2014 study published in the Proceedings of the National Academy of Sciences estimated that at least 4% of death row inmates are likely innocent. But statistics cannot capture the psychological devastation that follows when an innocent person spends years, sometimes decades, preparing to die for something they never did. The journey begins with a wrongful conviction, built on the quicksand of flawed evidence, prosecutorial misconduct, inadequate legal defense, and eyewitness errors that appear certain until DNA or reinvestigation proves otherwise. Research from the Death Penalty Information Center reveals that official misconduct, perjury, or false accusations are present in over 80% of death row exonerations. 4 black defendants, who comprise 54% of death row exonerees despite representing 41% of those sentenced to death, the system's failures are even more pronounced. The road to exoneration is 4 years longer for black inmates on average, a delay that compounds the trauma of wrongful imprisonment. Kirk Bloodsworth knows this reality intimately. In 1985, at 22 years old, he became the youngest person sentenced to death in Maryland. An honorably discharged Marine who worked as a waterman harvesting shellfish and fish along the eastern shore, Bloodsworth was convicted of the rape and murder of 9-year-old Dawn Hamilton. 5 eyewitnesses placed him with the victim. No physical evidence connected him to the crime. A polygraph test he passed was deemed inadmissible by the judge. The jury took just 1 hour to convict him in a state that, at the time, did not require unanimous verdicts for death sentences. While confined, Bloodsworth read voraciously in the prison library, teaching himself criminal law. One day in 1992, he came across an article about a British case in which DNA evidence had convicted a murderer and freed a man who had falsely confessed. He could barely pronounce deoxyribonucleic acid, but he understood its promise. After relentless lobbying, prosecutors agreed to test biological evidence, traces of semen found on the victim's underwear, that had been thought destroyed but was eventually located in a paper bag in the judge's chambers. The DNA results excluded Bloodsworth. In June 1993, after nearly 9 years in prison, 2 on death row, he walked free, becoming the first death row inmate in American history exonerated by DNA evidence. 10 years later, in 2003, a DNA database match identified the actual killer, a man named Kimberly Shea Ruffner who had been imprisoned at the same facility as Bloodsworth, lifting weights beside him, knowing the truth all along. Anthony Ray Hinton's ordeal began in 1985 in Birmingham, Alabama. A prosecutor with a documented history of racial bias told police that Hinton was guilty and evil just by looking at him. The entire case rested on the testimony of a state forensic examiner claiming that bullets from 2 restaurant murders matched a gun found in Hinton's mother's home, a dusty revolver that hadn't been fired in 25 years. Hinton had been working in a locked warehouse 15 miles away during one of the crimes, but his defense attorney, mistakenly believing he had only $1,000 available to hire an expert, retained a visually impaired civil engineer with no firearms expertise. The jury convicted Hinton. He was sentenced to death. Hinton spent 28 years on Alabama's death row in Holman Correctional Facility, most of it in solitary confinement. To survive mentally, he created elaborate fantasies, imagining dinners with Queen Elizabeth, playing for the New York Yankees, marrying famous actresses. He organized a book club in the prison law library where inmates, including a former Ku Klux Klan member with whom he formed an unexpected bond, read and discussed James Baldwin and Harper Lee. His mother visited him weekly, never doubting his innocence, but died in 2002 while he remained imprisoned. It was Bryan Stevenson and the Equal Justice Initiative who finally took his case seriously. They commissioned 3 forensic experts, including one from the FBI, to re-examine the ballistics evidence. All 3 concluded the bullets could not have come from Hinton's mother's gun. The State Court of Alabama refused to grant a new trial. In February 2014, the Supreme Court of the United States unanimously ruled that Hinton's original defense attorney had provided constitutionally deficient assistance. On April 3, 2015, prosecutors dropped all charges. Hinton walked out of the Jefferson County Jail at 9:30 in the morning. "The sun does shine," he said, embracing family and friends for the first time in 30 years. Alabama has never compensated him for those lost decades. These stories of exoneration represent victories of a sort, proof that the system can sometimes correct its most catastrophic errors. But release from death row does not mean restoration. For decades, the psychological aftermath of wrongful conviction was ignored. Researchers and social workers focused on the experiences of criminals re-entering society after serving their time, not on innocent people released with nothing, their records supposedly cleared but their lives irrevocably altered. The few studies that exist reveal a landscape of devastation. In 2005, Dr. Adrian Grounds, a psychiatry professor at the University of Cambridge, conducted a clinical study examining 18 men who had been exonerated after wrongful imprisonment. None had a history of mental health issues before incarceration. Grounds found that the long-term psychological effects of unjust imprisonment manifested most severely only after exoneration, contradicting the assumption that freedom would bring relief. The majority developed post-traumatic stress disorder and depression. 14 displayed serious personality changes. Many developed panic disorder, paranoia, and substance abuse issues. Grounds compared these outcomes to those seen in military veterans and torture survivors who had endured extreme trauma. The reasons become clear when one considers the unique nature of death row. It is a place where time is weaponized against the mind. Inmates live in isolation, often 23 hours a day in a small cell, surrounded by the sounds of others being led away to execution. They witness fellow prisoners disappearing into the death chamber, knowing their own name will one day be called. They endure what researchers call anticipatory grief, a prolonged psychological state in which one grieves one's own death repeatedly over years or decades. Death row exonerees in particular report acute trauma reactions, including hyperarousal, feelings of hopelessness and apathy, intrusive thoughts about their impending death, and profound difficulty envisioning a future or connecting emotionally with others. Researchers Sandra Westervelt and Kimberly Cook, who studied this population extensively, found that many condemned prisoners had borne witness to executions, creating layers of trauma that compounded with each passing year. When exoneration finally arrives, it does not erase the damage. Virginia Ginny Lefevre was released at 59 years old in 2010 after serving a life sentence for her husband's murder, a crime she did not commit. Her husband had died by suicide, but a toxicologist testified falsely that the only explanation was murder by injection. When Ginny stepped into freedom, she discovered that the world had moved on without her. Her parents had passed away. Some of her children refused to speak to her. She had no job, no possessions except legal documents and a few books, and she developed severe PTSD. Darrell Hunt spent 19 years in prison for a murder he didn't commit. After his exoneration, he struggled to adjust. In 2016, he committed suicide in a parking lot. These are not isolated incidents. The psychological sequelae of wrongful imprisonment include not only PTSD, depression, and anxiety, but also persistent personality changes, adjustment difficulties, relationship impairments, chronic feelings of estrangement and isolation, and complex experiences of loss. Comorbidity is common. Many exonerees suffer from multiple disorders simultaneously. substance abuse and dependence become coping mechanisms for unbearable emotional pain. The conditioning required to survive in prison, the rigid routines developed to cope with fatigue and despair, the necessity of following orders and suppressing autonomy, these survival adaptations become maladaptive in freedom. Men from the Cambridge study who had been so conditioned to take orders from prison officials found it difficult to function in the unstructured environment of home. One exoneree, released after 30 years, had to relearn how to use a fork because prisoners are only given plastic spoons. The notoriety of capital cases adds another layer of difficulty. Death row exonerees often return to the communities where they were wrongfully convicted. Widespread misinformation fuels stigma. Even after being proven innocent, they face social rejection and hostility. Neighbors and strangers still believe they are guilty. Employment becomes nearly impossible. Many exonerees are denied access to reentry programs and state aid specifically because they were exonerated rather than having served their sentences. They are released with no money, no housing, no transportation, no health insurance, and sometimes a criminal record that is not cleared despite their innocence. They suffer from serious health issues, very limited employment prospects, lack of access to training programs, and challenges with securing and keeping stable housing. Because they were not guilty, they are excluded from the support systems designed for former inmates. Because they were imprisoned, they are excluded from society's compassion for victims. The need for mental health services for this population is urgent, yet support is almost non-existent. As of recent reports, Illinois is the only state that provides free mental health services for exonerees as part of a state-funded reentry program. This came after Governor Pat Quinn abolished the death penalty in Illinois in 2011 following 20 death row exonerations, the second highest of any state. Most exonerees have no such support. Compensation statutes exist in 37 states and the District of Columbia, but 13 states offer nothing at all. Even where compensation laws exist, they are often riddled with arcane loopholes, are not retroactive, or require exonerees to mount costly political campaigns for private compensation bills. In 2004, the Federal Innocence Protection Act created the Kirk Bloodsworth Post-Conviction DNA Testing Grant Program to help states pay for DNA testing, and this program has freed over 50 people, including many from death row. But prisoners still face significant procedural hurdles, resistance from prosecutors and judges, and the harsh reality that DNA evidence is available in only a fraction of cases. President George W. Bush once endorsed compensation of up to $50,000 per year of wrongful incarceration, with an additional $50,000 per year spent on death row. Adjusted for inflation, these figures should be higher today, yet many states refuse even this. Alabama has never compensated Anthony Ray Hinton. Maryland compensated Kirk Bloodsworth, but the maximum in Illinois is less than $200,000, even for those who spent decades in prison. The message is clear. These individuals were nearly killed by the state for crimes they did not commit, and upon their release, the state largely abandons them. The long-term impact ripples outward. Family members of death row inmates also suffer. Research documented by the Texas After Violence Project found high rates of depression and symptoms of PTSD among family members of capital defendants, death row prisoners, and those who had been executed. These families face many of the same challenges experienced by other groups traumatized by violence, but they also endure social stigma and guilt by association. As one 1983 study noted, in contrast to others facing loss, these families must know that the death of their loved one is actively desired by others. For family members of exonerees, the relief of release is tempered by the recognition of lost time that can never be recovered. The psychological toll extends even to those working within the system. Defense attorneys, investigators, and mitigation specialists who work on death penalty cases often serve as the closest thing their clients have to mental health treatment. Yet they must balance therapeutic goals with forensic goals, building trust while simultaneously extracting information for legal use. Clinical psychologists who work as consultants on these cases report that people on death row desperately need trauma-informed treatment from trained professionals who are not part of the defense team, but such resources are rarely available due to funding constraints. When clients face symptoms that cause them to break down before evaluations or threaten to give up their appeals, legal teams face agonizing ethical dilemmas. 1 in 10 prisoners executed in the United States are volunteers, defendants or prisoners who have waived key trial or appeal rights to facilitate their execution, often due to untreated mental illness. For those who are exonerated, the experience leaves a permanent mark. Anthony Ray Hinton, now a community educator at the Equal Justice Initiative, travels the country speaking about his experience and advocating for the abolition of the death penalty. He wrote a memoir titled The Sun Does Shine: How I Found Life and Freedom on Death Row, which became a New York Times bestseller and was selected for Oprah's book club. He has said that he forgave those involved in his conviction long before he left prison, not so they could sleep well at night, but so he could. Yet he also acknowledges the difficulty of adjusting to the simplest things we take for granted. Kirk Bloodsworth, who served as executive director of Witness to Innocence from 2018 to 2022, the only national organization composed of and led by exonerated death row survivors, played a key role in ending the death penalty in Maryland in 2013. He speaks frequently about the need for criminal justice reform and DNA testing. He wears ties decorated with the DNA double helix. "Science freed me and caught the culprit responsible," he says. "I believe in science." These stories of resilience are remarkable, but they should not obscure the reality that many exonerees do not fare as well. Some struggle with homelessness, addiction, and chronic mental illness. Some, like Daryl Hunt, do not survive the psychological aftermath. The therapeutic community has largely failed to recognize exonerees as a distinct trauma-affected group requiring specialized support. Social workers and clinicians who do work with this population emphasize holistic approaches to healing from trauma, storytelling, forgiveness, and peer connection. Annual conferences organized by advocacy groups provide exonerees with opportunities to connect with others who share their experiences, to engage in storytelling and healing practices, and to channel their devastation into serving others. For many, the opportunity to turn their suffering into advocacy becomes one of the most rewarding outcomes following the tragedy of wrongful imprisonment. The desire for formal acknowledgement is also paramount among death row exonerees. Many express a need for the state to be held accountable, for an apology that recognizes the harms they have suffered. Yet such apologies are rare. Acknowledgement of innocence does not come with an admission of systemic failure. Compensation, when it is provided, is framed as a financial transaction rather than a moral reckoning. The individuals who played a role in wrongful convictions, the prosecutors, judges, forensic experts, and law enforcement officers, rarely face consequences for their actions. In some cases, such as Anthony Ray Hinton's, the prosecutor had a documented history of racial bias, yet continued to work in the system. In Kirk Bloodsworth's case, the original defense attorney mistakenly believed he lacked funding for a competent expert. In both cases, the failures were compounded by appellate courts that upheld convictions despite glaring problems. The racial dimension of these failures cannot be ignored. Defendants of color constitute 52% of those sentenced to death over the past 50 years, yet they make up 64% of death row exonerees. Black defendants are 54% of death row exonerations. The leading causes of wrongful capital convictions are official misconduct and perjury or false accusation, and both are more prevalent in cases involving defendants of color. Exoneration takes significantly longer for black defendants, an average of over 4 years longer than for white defendants. 12 of the 13 post-Furman wrongful convictions that have taken 30 years or longer to exonerate involved African Americans. The death penalty, as many abolitionists argue, has its roots in slavery, lynchings, and white vigilantism, and the racial inequities in sentencing and exoneration persist to this day. The question then becomes what justice looks like after exoneration. It begins with acknowledging the full scope of the harm. Exonerees are not simply people who serve time for crimes they didn't commit. They are torture survivors. They endured years or decades of state-sanctioned psychological torment, isolated from loved ones, stripped of autonomy, and forced to confront the prospect of their own execution. The trauma does not end when the cell door opens. It follows them into every interaction, every attempt to rebuild a life, Every moment they try to reconnect with family or find work or sleep without nightmares. True justice would include immediate provision of subsistence funds and access to services critical to a successful return to society. This means housing, food, psychological counseling, medical and dental care, job skills training, education, and any other assistance needed to rebuild lives that were shattered by wrongful conviction. It means clearing criminal records completely and automatically upon exoneration. It means compensation that reflects not just lost wages but the immeasurable suffering endured. It means statutes that do not contain arbitrary time limits, requirements for legislative enactment, or loopholes that allow states to deny compensation on technicalities. It means training for mental health professionals who can recognize and treat the specific trauma of wrongful death row imprisonment. Perhaps most importantly, it means preventing these injustices from occurring in the first place. The fact that at least 4% of death row inmates are likely innocent, according to research estimates, should be unacceptable in any society that claims to value justice. The fact that one person has been exonerated for every 8 people executed means that the machinery of death operates with an error rate that would be intolerable in any other context. The fact that the leading causes of wrongful capital convictions are official misconduct and perjury, often intentional acts rather than innocent mistakes, suggests systemic problems that require systemic solutions. These solutions include better funding for indigent defense, rigorous oversight of forensic testimony, elimination of prosecutorial immunity for misconduct, preservation of biological evidence for future testing, expanded access to post-conviction DNA testing, and ultimately, many argue, abolition of the death penalty itself. Kirk Bloodsworth has said he would rather see a person sentenced to life in prison than executed for something they didn't do. He doesn't want anyone imprisoned for crimes they didn't commit, but at least in prison they won't die. They have a chance to prove their innocence. They have a chance to walk free. On death row, time runs out. Executions are irreversible. And in a system where error is not just possible but demonstrably common, irreversibility is unacceptable. The psychological aftermath of exoneration from death row is a crisis hiding in plain sight. It affects a small number of people, just over 200 in the modern era, but each individual story represents a profound failure of justice and a debt society has yet to repay. These survivors carry invisible wounds that manifest in PTSD, depression, anxiety, personality changes, and all the complex ways that trauma reshapes a person's relationship with the world. They deserve not just freedom but healing. They deserve not just compensation but recognition. They deserve not just apologies but accountability. As we consider the future of the death penalty in America, the experiences of exonerees must be central to the conversation. They are living proof that the system makes catastrophic mistakes. They are witnesses to the psychological devastation of death row. They are advocates for change who speak from a place of unimaginable authority. And they are reminders that behind every statistic, every court case, every policy debate, there are human beings whose lives have been irrevocably altered by decisions made in the name of justice. The sun does shine, as Anthony Ray Hinton said on the day of his release. But for many who walk out of death row after proving their innocence, the light can be blinding. The world outside has moved on. Loved ones have aged or died. Technology has advanced. Culture has shifted. And inside, the exoneree carries the weight of years spent in a cage, awaiting an execution for a crime they never committed. Freedom is just the beginning of a journey that society has barely begun to acknowledge, let alone support. In the end, the question is not just how we prevent wrongful convictions, though that is critical. It is also how we respond when they occur. How we support the survivors. How we hold the system accountable. How we ensure that those who were nearly killed by the state for crimes they didn't commit are not abandoned to face the aftermath alone. The answer will test our commitment to justice, our capacity for compassion, and our willingness to confront uncomfortable truths about a system that is supposed to protect the innocent but too often destroys them instead. The stories of Kirk Bloodsworth, Anthony Ray Hinton, and hundreds of others like them are not just stories of wrongful conviction and eventual exoneration. They are stories of psychological survival, of resilience in the face of unimaginable adversity, and of the invisible aftermath that follows when the state admits its mistake but offers little else. These are the stories we must hear, the experiences we must honor, and the lessons we must learn if we are to build a justice system worthy of the name. Because until we do, the shadow of death row will continue to haunt those who escaped it, a reminder that freedom without healing is only half a victory, and justice delayed is not always justice delivered.